Hi everyone. In this session we are going to talk about the resolution of interstate water disputes, primarily focusing on what are the constitutional provisions on that and what kind of practices has been involved in the resolution of the major interstate water disputes. So, that is what we will be discussing in about next half an hour. To begin with, the Article 262 of our constitution says that Parliament may by law provide for the adjudication of any dispute or complaint with respect to the use, distribution or control of the waters of or in any interstate river or river valley. So, the right to basically look after the disputes or interstate disputes relies to the union. The government, the central government has that power. Now, notwithstanding anything in this constitution, Parliament may by law provide that neither the Supreme Court nor any other court shall exercise jurisdiction in respect of any such dispute or complaint. So, these things were taken out of the jurisdiction of the court, and the Parliament was given authority by law to look after the adjudication of such disputes or complaints arising over the interstate river or river valleys. So, this was the Article 262 of the Indian Constitutions, which provide the union government or central government the right to look after the disputes. Then under this act, under this Article 262, a River Board Act was passed in 1956, okay, which proposed that the union government will create boards for interstate river and river valleys in consultation with state governments. So, the River Board Acts was primarily about creating or establishing river boards for particularly for interstate rivers. The objective of river board was to advise on interstate basin, to prepare development schemes and to amicably see out the sharing of water in such a way that conflicts does not arise. Okay. So, the idea was that such board will act accordingly, so that the number of conflicts or number of interstate conflicts could be reduced or could be minimized. However, under this act, sort of no river board has been formed or has been constituted so far. So, although this act was passed, but not used much. There has been attempts been made to basically form a river board few times, but again it could not formalized because of various issues. Then under that Article 262 only, the power which was given to the Parliament, the Interstate Water Dispute Act was passed in 1956. Now, this act has sort of been a key player or key act in order to dealing with such interstate water dispute cases. How successful this has been, that is a big question though, but at least there has been attempts been made under this act to tackle or to observe, to consider the such disputes on a union government level. So, what is there in this act? Well, this act suggests that in case of disputes among states, the central government should try to resolve the matter by consultation among the aggravated states. So, act suggests that the government can basically help or facilitate consultation process between the state, and if that does not work, then the central government is empowered to constitute a tribunal. So, this tribunal shall have same powers as are in a civil court under the Code of Civil Procedures 1908, and this tribunal will then consider, will then take care of the case and eventually will analyze the case, will try to understand the system, try to see what are the demands, what are the realistic scenarios, what are the issues and problems with the participating states, and based on that it will give its sort of word, its final decision about the resolution of the dispute or sharing of the water, because all such interstate water disputes primarily over the sharing of water in the different interstate river basins. The tribunal actually acts like a court, okay, and it was given power also as good as a court, so that when it says that it has a power that are vested in the civil code, so that means it can summon anyone, it can basically call anyone, it can basically sort of do all the things that court can do, a civil court can do. Now, this tribunal's basic role was to investigate the matter, refer to it and give a decision, which was also called award. So, give a award on the issue. Okay. Tribunal consists of a chairman and 2 other members. So, as per this Interstate Dispute Act of 1956, a tribunal will have 3 members, 1 chairman and 2 other members, and will be nominated in this behalf by the Chief Justice of India. And who are going to be the member? The members are going to be the judges from the Supreme Court or of a High Court. So, tribunal was basically constituted by the government, but the members are nominated by the court and from within the community of the judges from the Supreme Court or are of High Court. Now, this decision of this tribunal is final and binding on the parties. So, parties were sort of liable to follow whatever the decision or award has been given by the tribunal. Okay. The parties has to give effect to it, means they have to give at the time of constitution of tribunal, they have to basically agree that they will abide by the decisions or award being given by the tribunal. Supreme Court will not question the judgment of the tribunal, will not question, will not have an authority to question the decision of a tribunal or the formula that tribunal suggests for resolution of the issue, resolution of this dispute. However, it can question the working of the tribunal, whether tribunal is working fine or not, or who are the parties in the tribunal, on the timeline thing. So, all the other things it can basically question. People can go to Supreme Court, parties can go to the Supreme Court and question that. However, by law of this Dispute Act, Supreme Court has no authority to question the final decision or award or the formula for the dispute resolution proposed by the tribunals. So, we have several tribunals constituted of this effect, and the major some of the major interstate river water disputes which were attempted to consider under the Interstate Water Dispute Act 1956 are listed here. So, we had Krishna, which is one of the major disputes between Maharashtra, Andhra Pradesh and Karnataka. There was Godavari, then Narmada dispute where Rajasthan, MP, Gujarat and Maharashtra were the party. We had Kaveri dispute, okay. The Kerala, Karnataka, Tamil Nadu, main is the Karnataka and Tamil Nadu, but Kerala and the Pondicherry are also the parties. Then there is Mandovi or Mahadai Nadi, so that Goa, Karnataka and Maharashtra, and then Vansdhara between Andhra Pradesh and Odisha. So, these are the major disputes which has been considered under the Interstate Water Dispute Act. There was certain issues with this act, or so in case of Godavari water dispute, the request was made in 1962, the tribunal was constituted in 1968, the 6th year after the request has been made, and final award came in 1979, around 11 years after the tribunal was constituted, okay, and that further got gazetted in the Government of India's Gazette in 1980. So, the delays are quite apparent in such cases. In Kaveri water dispute, it was even more delayed. So, Tamil Nadu government requested to constitute the tribunal in as early as around 70. Then only after the intervention of Supreme Court, the tribunal was constituted in 1990, almost 20 years after, and the award of the tribunal or the decision of the tribunal was given in 2007. Similar delays has been in many other cases. Okay. So, the tribunals take some 10 year, 15 year or higher period for giving their decisions. The problem is that if there is delay in the constitution or tribunal or award of the tribunal, so state governments in the meantime can carry on their investment in the resources or can carry on basically the construction and modification through dams and these kind of things. So, that further strengthens their claim in the tribunal also, that okay, I have constructed a dam, now I have to basically operate this catchment of the dam is or the minimum threshold storage of this has to be maintained. So, I can release water only which is above this, water below this is not practically possible to release until unless that dam is destroyed, so or decommissioned. So, those kind of cases are quite apparent. Okay. There has been many such attempts has been made in the quite a few water disputes, that by the time the dispute is under the consideration, the further developments keeps on taking place at a state level, and that aggravates problem to a larger degree at times. There has been amendments in this Interstate Water Dispute Act of 1956, which was done in 2002. So, this amendment, one amendment that was important amendment that was made was that this tribunal should give award within 3 years, and in certain situations when there is, let us say, unforeseen chances or there are unavoidable delays occurring. So, 2 more years can be given to the tribunal for giving decision. So, the maximum time period of 5 years was sort of fixed for the tribunal to give the award. So, the tribunal has to basically give its decision within a period of 5 years. The concerned parties may seek clarification within 3 months of the award. So, in order to expedite the process, it says that if the parties has any concern or parties are sort of not agree, so they can file a review petition or they can file a case for within the tribunal for the review within 3 months of the award. It also clarified that tribunal awards will have the same force as the order of the Supreme Court. Okay. So, that means the award shall be beyond the jurisdiction of the Supreme Court, because if the tribunal award is as good as an order of Supreme Court, so Supreme Court does not reconsider generally its own order. Okay. And that is why, moreover, if you see the structure of the tribunal, so tribunal is to be framed by the judges from the Supreme Court, bench of the Supreme Court or High Court. So, it is a kind of judiciary only, because the decisions are being given by the judges panel of 3 judges with 1 chairman and 2 other judges. So, when this kind of judiciary is involved in decision making, there is no point in basically taking that further to the court, to the bench of another judges and those kind of problem. So, that is why it was mentioned that award shall be final and beyond the jurisdiction of Supreme Court. However, there are variety of issues are there even after that amendment also, that although the award was considered final and beyond the jurisdiction of the courts, but what has been often observed that the either states, means whosoever are the party, any state which is a party can approach Supreme Court under Article 136, which is the special leave petition. So, an SLP can be filed and the decision of the tribunal can be basically questioned or can be challenged under an SLP. Further, even the private person can also approach to the Supreme Court under Article 32, linking issue with the violation of Article 21, which is right to life. So, it is like, let us say court gives a decision to a state A that release this much of water to state B. Now, a person from state A files a PIL, public interest litigation, that okay, if a state gives this much of water to the to the subsequent or lower riparian states. So, then what will happen, that our demands are not getting fulfilled and we are getting basically the water which is important thing under the right to life will be basically withdrawn or will be taken from us, and those sort of issues can arise. So, although the act says that the award is beyond the jurisdiction of the court, but that is actually not the case, okay, because the state has authority to go to the court under SLP, or even a private person or even a NGO can file a PIL or can file a basically petition under Article 32 linking with the violation of right to life. So, in such cases this becomes very difficult. There are other issue is that the composition of tribunal is not multidisciplinary. So, a tribunal which looks after the case has only people from the judiciary. They are not the experts, there is no one to basically look at the actual field condition or may not have that understanding of a perspective of a water resources person or a hydraulics engineer or a sociological activist. So, the idea is that like the constitution of the tribunal which is from the judges. So, this is not much difference than a Supreme Court bench, because Supreme Court bench could also have 3 judges, 5 judges, those sort of things can be there, and tribunal also constituted only of the judges. So, it was definitely not the multidisciplinary, and many times the perspective, field perspective and real perspective are not that well communicated or not that well understood by the tribunals. Further, tribunal works were delayed due to the lack of availability of data, okay, because any decision, any such decision has to be made. Let us say a tribunal is looking after the case of water dispute between 2 states. It will like to know that okay, what is the catchment area of the 2 states under this river basin, how much the water inflow is in the 2 basins. Now, these numbers, particular catchment area is fine, but how much water inflows in the river is a number which changes from year to year, month to month. There cannot be just one single data. Okay. Further, what are the irrigated area, what is the population living, what is the demand from the population, what is demand from the industries, what is demand from the irrigation sector. So, all this information must be made available to the tribunal or to the expert committee in order to take a decision. Any decision taken without having adequate amount of data may not actually may not be in the line of the social equity principles. So, the data or the importance of the hydrological data is very important in making such decisions, and because river boards were not established, because there are not as such central mechanism which can collect and which can share the data. So, state may give their own data which can be like at times overestimated or underestimated depending on the what kind of advantages they want to take or what kind of projections they want to make. So, those kind of issues were also there, and since there is no central agency or no one single agency or one nodal agency which keeps a track or which keeps a record of the data, it becomes very much difficult for the tribunal to get hold of the true data. So, to overcome some of these points, there has been a bill proposed to the parliament. It has actually been proposed to the Lok Sabha last year only. So, it is a recent bill which is Interstate Water Dispute Amendment Bill 2017. So, this bill was introduced in the March 14, 2017, although it has not passed yet from both the houses, okay, but it was introduced in the Lok Sabha and by the Minister of Water Resources, River Development and Ganga Regeneration. This bill proposes a single standing tribunal with multiple benches instead of existing multiple tribunals. So, so far under the Interstate Water Dispute Act, the provision is that for each dispute, for each conflict, there will be a tribunal, there is a possibility of setting up a tribunal. So, if we are having let us say 10 number of river disputes coming in, so we have to set 10 number of tribunals. So, the proposed bill gets away with that idea. It says that there has to be a single standing tribunal with multiple benches instead of like existing multiple tribunals. So, instead of having many number of tribunals, the government shall have a single tribunal which works for all such cases. This tribunal shall consist of one chairperson, one vice chairperson and not more than 6 other members. So, the size of tribunal has also been increased. So, there has to be one chairperson, one vice chairperson, and there has to be some around 5-6 members, not more than 6 members. The tribunal, which is single standing tribunal, can have like the part of the tribunal or this can have one, but there could be different experts for the different cases can be brought in. So, bill also provides an opportunity for the appointment of an assessor to provide technical support to the tribunal. So, for helping in the decision making to the tribunal, independent assessor can be appointed who provides the technical support. Now, this independent assessor has to be amongst the experts serving in the central water engineering services. So, has to be basically a well educated, well trained expert, not below the rank of a chief engineer. Okay. So, that was the sort of proposition done under this amendment bill. Then the bill also proposes that tribunal has to be given a decision on dispute within a period of 2 years. So, earlier there was sort of with the original bill it used to take long, then the 2002 amendment suggested that it has to give a decision in the period of 3 years and which can at max be extended up to 2 years. So, still got a 5-year window, but this amendment bill suggests that the decision has to be basically given in a period of 2 years and this period is extendable by maximum of 1 year. So, in a total span of a period of 3 years, the decision has to come. Okay. So, that was the one of the ideas of this amendment bill, to basically expedite the process, so that the process should not take too long in that sense. Then the bill also proposes to introduce the mechanism to resolve the dispute amicably by negotiations through a dispute resolution committee. So, the bill says that the central government can constitute a dispute resolution committee consisting of relevant experts before such disputes goes to the tribunal. So, it is not necessarily that any dispute is directly sent to the tribunal. A dispute resolution committee specific to a case of dispute can be set up, which can actually see the possibility of the negotiation, possibility of the amicable negotiation for resolving that dispute, and if that dispute is resolved through negotiation, there is no requirement of sending that dispute to the tribunal. So, members of this dispute resolution committee has to be relevant field expert, and basically as suppose as the appointment is to be done by the central government. So, it is under the jurisdiction of the government that whom they appoint, but the idea is to have a field expert or experts from the field to be basically part of this dispute resolution committee and try to resolve the dispute in a scientific or social way or through just negotiations. The new bill also proposes to basically provide for transparent data collection system, because that is one of the major challenges in front of the tribunal, because they do not get hold of the real data in timely manner, and that makes it difficult for them to basically arrive at a decision quickly. So, the bill says that there has to be a transparent data collection system at national level for each river basin for this purpose. So, agency that maintains the data bank and information system shall be appointed or authorized by the central government. So, central government will have a right to authorize or appoint a committee or basically a agency for collecting the data, managing the data, and putting that in a basically information system for which can be used for helping resolution of such disputes. So, overall if we see, the bill proposes to streamline the sort of resolution of these interstate water disputes and present a legal and institutional architecture robust. Okay. So, with a like a specific dispute resolution committee, then timely manner decision, transparent data collection system. So, all those things were in order to basically improve the bill, looking at its earlier shortcoming, and that is how this was sort of framed. So, this way the our constitutional provisions suggest for the resolution of disputes. We will end this session here, and in next session we will see we will take up a case study and see how the resolution takes place, or how the disputes are basically managed under such conditions. So, that we will discuss in the next session. Thank you.